Welcome, everybody, to our Community Justice Academy. And it is so good to see everybody. Once again, we are doing this virtually. And it's hard to believe it's been 1 year since we last did this, and it's hard to believe that we're still doing it virtually. But it's so good to see so many familiar names and faces on our Zoom screen here to be able to see everyone once again. Hopefully we can do events like this in person. But we appreciate everybody's willingness to join us and continue to participate in these programs as we talk about the criminal justice system through our Community Justice Academy. This is the 11th year that we've done this. We do this every October, and we try to take on a topic based on the suggestions that we get from you, the community. And one of the biggest topics that we get is the process of jury selection. And what does that process look like? What does it take for someone to be qualified as a juror on a criminal case here in Marion County? And what are some of the things that go in for the judge's perspective? What things do a prosecutor or a defense attorney consider as they work through the process of selecting a jury here in Marion County? And so just so everybody knows, when we talk about jury selection, Marion County does more juries than anybody in the rest of the state. And so if you look at just by sheer volume of numbers, the Marion County Prosecutor's Office is responsible for about 20% of all juries that take place in the entire state of Indiana, both criminal and civil. So when you hear somebody talk about jury trials, the vast majority of that work is taking place here in Marion County through the Marion County Prosecutor's Office. And I think it's an incredibly important feature and aspect to have, because to me, one of the most important things is that we get feedback from the community. And one of the best places to get feedback from the community is through a jury trial. It helps us better understand the community's expectations of the prosecutor's office, the community's expectations of law enforcement, and really helps provide for community input into how our criminal justice system operates and works. And so we're feel very fortunate and incredibly grateful that this is the system that we have, because this is not a system that exists everywhere. But it's one that we have here in the United States, and I think it's a pretty good system. And we want to tell you a little bit more about this process, how it works, and what goes on. And so, just to kind of generally speaking, open up the topic of voir dire, which is what we call jury selection. What happens is we bring in people from the community, and we are looking for fair and impartial individuals to sit on a jury. And they are randomly selected from the community, and then they're the people who ultimately decide if a person's guilty or not guilty. And to really delve into this process a little bit more, we have a great panel with us today. We have a retired judge, an active deputy prosecutor, and Lindsay Corbett, as well as Dan Cicchini, who's going to help moderate the discussion for us. And so at this time, I'd like to introduce our panelists. Number one is Lindsay Corbett, who's a deputy prosecuting attorney in the Marion County Prosecutor's Office. She joined the office in 2015 and has represented the state of Indiana approximately 40 jury and bench trials, everything from low-level misdemeanors to homicide cases. In January of 2021, she was promoted to serve as Director of Recruitment, Development, and Internships. And she's focused on recruiting and training attorneys with a commitment to creating a fair and equitable criminal justice system through data-driven policy reform. She's also co-chair of the office's Diversity, Equity, and Inclusion Council. She is a two-time All-American from Butler in track and field. She ran, was it the 200? What'd you run?
400 hurdles.
400 hurdles. So she's tough to catch, but she's a phenomenal prosecutor and someone that we really enjoy getting to work with. And one of the people that she was fortunate enough to practice in front of is Judge Lisa Borges. Judge Lisa Borges is a retired judge here out of Marion County. Judge Borges was elected to the Marion Superior Court in 2006. And during her tenure on the bench, she primarily presided over major felony cases. Prior to her election to judge, she was a deputy prosecuting attorney for 18 years, prosecuting violent crimes and specializing in sex crimes and the presentation of DNA and forensic evidence. And I believe she was the first prosecutor to actually use DNA evidence in a criminal prosecution here in Marion County. And she has served as chief deputy in both Johnson and Marion County. And on a personal note, I had the pleasure of serving in Judge Borges's court. And she is a phenomenal judge. And one of the things that she always did really, really well was made people feel comfortable. When we talk about jury selection, one of the things that's really important is we need people to come in and be willing to share about themselves but they also need to understand the magnitude of what they are about to talk about. And also the magnitude of the obligation that they are taking when they are going to serve as jurors. And Judge Borges did a phenomenal job of balancing that, and she also did a really good job communicating with the jurors. And so now I'd like to turn it over to Judge Borges if she could kind of share her perspective as a judicial officer and walk us through the voir dire process from the judicial perspective and some of the things that she would say to prospective jurors. And the way this is going to work, Judge Borges is going to present, Lindsay's going to present, and then we invite questions from the audience about this process and all the materials that we're going to cover today. Dan Cicchini, who's also with us, he served as both a public defender and a prosecutor, so we thought he'd be a good person to moderate the discussion so he could kind of give the perspective of both sides. And so with that, I will turn it over to my good friend, the great Judge Borges. Judge Borges, take it away.
Thank you so much, Ryan. It's actually an honor to be invited to talk to folks today about voir dire, or voir dire, as Hoosiers usually say. It's one of my favorite parts of a jury trial. And during my time on the bench, I've probably been the presiding judge for, well, very close to almost 200 jury trials. So it's just an absolute ton of time that's spent working with folks from the community. If you were to come to my court as a juror, the first thing I would do would be, first of all, is stand up. And I'll explain to you as we talk about this for a few minutes why I would stand, because usually when I'm in the courtroom, other people stand up for me when I come in, right? Well, the fact that you become, as a juror, an extremely important person in the courtroom, that's one of the reasons we honor you by standing when you come into the courtroom. You become what's called the trier of fact. And so it's important to us that we know who you are. And so I would introduce myself and tell you a little bit about the court that you are in. And then I would just begin talking with you about who you are and what I think is important for you to know about the process. I'd ask questions of the folks that are in the courtroom, but I'd first let you get settled, let you figure out where you are and look around for a minute so you could see the courtroom itself. One of the first things I ask is whether I have any veterans in the courtroom. And it's always important to me to honor the service that veterans give our country. And that's important because it's something that is such a sacrifice. And I'm getting ready as a judge to ask you as jurors to make a sacrifice. So I want you to think for a moment about the sacrifices that members of our military give for our community, leaving behind family members for long periods of time, missing birthdays, celebrations, Christmas, Easter, all kinds of holidays that they are separated from their loved ones. Generally would be asking you for somewhere between 1 to 3 days of service. And almost always you would not be sequestered, meaning you would get to go home at the end of the day. So we talk about that. I talk about why the jury service is so incredibly important. The United States is one of the few countries that trusts its citizens with making big decisions about and resolving conflict. So in any criminal case, there's always conflict, right? Because someone's being accused of some sort of a criminal act. And then it's up to the state of Indiana to bring proof, and that proof has to be beyond a reasonable doubt. I usually explain that too. But it's important to me that you understand that the job of a juror is one that it is your duty as a citizen, and it does require a sacrifice because everybody has something better to do than sit in the courtroom and listen to me and listen to people talk about the things that another person might have been accused of. My practice has been primarily in criminal matters. Rarely did I do any civil work. So really, since I was pretty young, I've been involved with the criminal justice system. So there are civil trials that's a little bit different in a civil trial where there's a plaintiff and a defendant, and there's a complaint that has to be proven. Big difference is what's called the burden of proof. And that's something I would talk about as well. I would tell you I'll be looking for, if it is a level 6 felony or lower trial, I'd be looking for 6 people. In a major felony trial, I'd be looking for 12 people that could be as free from bias and prejudice as we could manage. We want to have fair and impartial people, but you and I know that you don't get to be 18 years of age without having some firmly held opinions, and some that you really need to test sometimes in order to serve as a juror. So I would be looking for those folks who would be willing to set aside those biases and prejudices, listen to what the lawyers have to say about the law, what I have to say about the law, and then listen carefully to the evidence that gets presented. I would go on to talk about, I have to go back and look at my book and see what I normally would do next. I would talk about juror conduct, and that's something that's important. If you're selected as a juror, it's important that you know that there are some things you can do, some things you can't do. One thing is that you can't talk about the case. Once you've been sworn in as a juror, you're not allowed to tell anybody else about anything that you've heard in the courtroom. There's a really good reason for that. And I like to explain it by saying, suppose there's a person who's one of my jurors that was accused of having a steak for dinner. We could bring people in, swear them in, talk to them about what they saw, what they heard. They might bring different kinds of evidence in. Maybe, people have suggested maybe there'd be a video, maybe there would be a receipt, other kinds of evidence, mainly the testimony from other people, which is evidence. And then the jurors would be asked to determine whether they believed that the evidence met the burden of proof. And that burden of proof is what's called beyond a reasonable doubt. It's not beyond all doubt. It's not beyond a shadow of a doubt or 100% guilty. And there's a good reason for that. Because in order for you to know for certain that that person accused of having a steak for dinner actually had a steak for dinner, you'd have to see it yourself. If you saw it yourself, it would mean you're a witness. And witnesses can't serve on a jury. Does it begin to make a little bit of sense then as you think about why our burden is beyond a reasonable doubt? It's still a very high burden. And the law requires that burden be met, but there's no way that you could prove something beyond all doubt. So those are some of the things I would do. I'd also introduce the lawyers to you. I usually talk for a while before I introduce them, but the attorneys, it's important to me that you would know as jurors that you're not going to see a knockdown drag out between the lawyers. It's certainly not like television. The lawyers might not always agree on things, but both sides are very clear on the law. And if there is some dispute about what the law actually is, I'm there to resolve it. And I would call them up to me. Sometimes you might hear them say, "Judge, can we approach?" And they come up and talk to me up at the bench and ask me to resolve maybe a point that they want to make. And sometimes they'd come up and ask me how I want them to make a point particularly. Because as the judge, I'm required to take care of the courtroom. And in my mind, one of my biggest jobs is to take care of my jurors, to make sure that you're treated fairly, that we give you regular breaks and make sure that you get time to eat, time to rest, time to go to the bathroom, which is always a big thing. People worry about that, I know. So we try hard to take care of our jurors. I would ask certain questions that are required by law. And one of the things that is top of everybody's concern is how you get out of jury duty. In my career, obviously, there are times where I go to some event, somebody finds out that I'm a judge or that I'm now a retired judge, and they may have just gotten a summons for jury duty, and they'll say, well, what do I have to do? How do I get out of it? And I always tell them the same things I've told you about why it's so critically important that we have jurors. We can't do a jury trial without jurors. But I would explain that there are two ways to be excused. One is a challenge for cause. For instance, if you had tickets to go to Jamaica or something, then during the period of time the trial was going to be presented, it would be extremely unusual for a judge to make you stay. If you have a loved one who's in the hospital and you are needed to be there for decision-making purposes, you would not be asked to stay. We might, under some circumstances, depending on what it is that the problem is, that's a conflict that you feel you have, we might be asking you to reschedule and come and serve another time. But primarily those big issues might be cause issues. For instance, maybe you're related to one of the witnesses, maybe you know something about the case, maybe, those are all things that could make it difficult for you to make a fair and impartial decision about the presentation of the evidence, et cetera. So that's one way. And one of the lawyers might say to me, Judge, I challenge this juror for cause. And it's certainly not anything that juror did that was wrong. It's just simply that they think they've developed in questioning some sort of problem that needs to be addressed. The other way to be excused for cause would be what's called a peremptory challenge. Each side has a certain number of challenges that they can use for any legal reason. And I'm the arbiter of whether it's a legal reason or not, but I can tell you that it is the lawyers that I have had practicing in my courtroom are all very experienced. They know the law, they know what they can do and what they can't do. Generally, I think what I see is that the lawyer will set up in their mind this profile of the kind of person they're looking for, right? And so they're going to design their questions to try to pull from those jurors the information that helps them decide whether that person meets that profile in their mind. Maybe if the defendant, for example, is 18 years old, you may not want a whole lot of people that have 18-year-old children. You know what I mean? That might make it harder for them. So those are the kind of things when I say that, that's what I'm talking about. So I go through all those things. We would read the charges for you so you'd have some idea what the charge was that you would be hearing about. The lawyers are not allowed to tell you about the facts of the case because what they're really doing is deciding whether you're qualified to serve, and that's it. Just those basic qualifications. You're over the age of, you're 18 years or older. You live in the county in which you're being asked to serve. You don't know any of the witnesses. You don't know the defendant. Let's see, what else? You're not a law enforcement officer. Police officers, sworn law enforcement officers are not allowed to serve on criminal matters. They're considered to be parties with any criminal case, and so they can only serve on civil cases. So those are some of the things that I would go over with you. I'd make sure you could read and write English, etc. And I'd make sure that you weren't currently serving a sentence or somehow have your right to vote inhibited by a criminal conviction and that right not yet restored. Those are things that I would ask about. And then I'd ask if you'd served as a juror in the last 2 years. Those are the basic qualifying questions. And as long as you could answer all those easy questions, I would want you to stay with me. And then we'd get to a point where I would turn it over to the lawyers. generally we'd have a discussion about that burden of proof, similar to what I talked about earlier. And I'd ask the jurors whether they feel they may be biased one way or another, for the defendant, against the defendant in some way, or have any other reason that they don't think that they could be a fair and impartial juror. So I'd invite that discourse. I'd also tell them, if you have something that you want to tell me and you don't feel comfortable saying it in front of the whole room, I would invite you to come up to the bench. I'd bring the lawyers up too, because they'd have to hear what you had to say, for me to decide whether it would be fair for you to stay, or not, but you wouldn't have to necessarily say whatever it is outside in front of everybody, especially things like child molest cases. Those have been ones that have been difficult for people to tell about different backgrounds. I've talked now for a little about somewhere close to 15 minutes. And I usually try to have my general comments take 15 to 20 minutes in a trial, unless somebody else has a whole lot of questions. So I think at this point, I've kind of given you an idea of what I would talk about. So hopefully that has been helpful. And if there's something, Ryan or Lindsay, that you want me to talk about specifically, I'm happy to do that.
Well, thank you very much, Judge Borges, and kind of walking through those obligations. And before we turn it over to Lindsay, you touched on both the for cause and preemptory challenges, which is a way that someone could be excluded as a juror. If you would, Judge, one of the topics that frequently comes up is this idea of who serves on the juror in terms of what's the racial makeup and who should be qualified to serve as a juror. I know there's a lot of conversation about race neutral reasons for striking someone from a jury. If you could just give us a little bit of background on what the law is for a race neutral reason to remove someone from a jury and how that process worked in your courtroom.
Okay, I'm glad to do that. Frankly, there's a long body of law with regard to what's important to keep in mind with regard to selecting jurors. And it's critical that race not be something that enters into it, obviously. We're really careful in how we do jury selection. First of all, the summons go out. The judge has nothing to do with who the summons go to. We usually, the last jury I did, I think we sent more than 300 summons just so that we could get 50 people to show up. And so, I would have no way of knowing which 50 people are going to show. I'm, hopeful that we would have a really good showing, right? And when they would be brought to my courtroom, those folks are put in a randomized order by an algorithm in the computer that I don't have anything to do with and the parties have nothing to do with. So they're put in a random order. Nobody goes through the list and says, gee, this looks like somebody I want to have in seat number 3. Nothing like that, right? We have the questionnaire that the jurors fill out, and I'm very careful, and my colleagues on the bench are very careful about keeping people in the right order. So during the questioning by the lawyers, if one side or the other believes that someone is being excluded because of race, they have the opportunity to bring it to my attention to make an objection. And it's called a Batson objection, basically saying that for some reason they believe that this person's being excluded because they happen to be one race or another that they don't see as advantageous for whatever reason. So then it would be up to me to then turn to the state, for example, and say, so tell me about your race neutral reason for excluding this individual. I said earlier about that whole idea of figuring out what are the qualities of a person that you think would make a good juror. A race neutral reason might be this person has an 18-year-old son. The defendant happens to be 18 years old. His son went to tech. This defendant went to tech. It could be something like that. And if I felt that it was race neutral, to me, that's a pretty good reason to exclude someone because it may be too emotional for them. Additionally, there could be someone that talked about the fact that they had an experience as a child. Maybe it's a child molest case. They had an experience as a child. They said, it's not going to bother me. But for some reason, that's the prosecutor turns to me and says, well, that's the reason I excluded them. I didn't exclude them because they happen to be a certain race. So I don't know if that helps you, but it would be up to the judge to determine within the bounds of the law what is exactly, whether that explanation for excluding someone really was race neutral or not.
Thank you, Judge, for that very excellent explanation. And can I vote for you to put you on the Supreme Court? How does this work? Judge Porter to the Supreme Court.
No.
Oh.
Thanks kindly.
Well, I appreciate the hearing kind of the perspective of the judge and what a judge tries to do. And then from there, I want to turn it over to Lindsay Corbett to kind of walk us through the process of what attorneys are thinking as they begin the voir dire selection process. Lindsay?
Yeah. Good evening, everyone. As Prosecutor Mears has already stated, my name is Lindsay Corbett. I am a deputy prosecutor with the Marion County Prosecutor's Office. I've been with the office since 2015, and I had the honor of serving in major felony with Judge Borges, who you just heard from. And I did that for about 2 years prior to the position that I am in now. And I always found that when she gave that speech to jurors in the beginning, that did make them a lot more comfortable and prepared to answer questions from the attorneys when we got up. So I made a PowerPoint that you will all have access to at the end of this session. So I'm going to share my screen for you. Okay, is everyone able to see that? Dan, or can someone on the panel let me know if you're able to see the PowerPoint? Okay.
We can see it, Lindsay.
Awesome, thank you. All right, so what I'm going to be discussing with all of you is the prosecutor's approach to jury selection. Arguably, and I say arguably because some people say that this is not the most important part of the trial, but I'm going to go ahead and give my opinion and say that I think it is, because either the 12 or the 6 people that we select to serve on a jury are ultimately the people that are going to be deciding the outcome by a unanimous verdict. That means every single person has to vote to convict, and that's it. There's nothing else we can do. We can't prepare the jurors to make a decision. We can only prepare our case and the evidence that we're going to present. So it can be very challenging for attorneys to, make sure that we have a good jury. I would say that the jury selection process for us is very similar to an interview. So if you've ever interviewed someone for a job, you have a certain set of questions in mind that maybe the person may not know why you're asking them, but you have an idea of the job that you want them to do. So that's kind of, your approach to an interview. And that's essentially what us attorneys are doing, because we know all of the facts of our case, and we are just looking for jurors that are going to be fair and able to make a good outcome on our case. One difficulty that we do have as attorneys is that the time that we have for doing voir dire is very limited. In Marion County, we usually only have about 30 minutes for major felony trials. So I think by Dan's calculation earlier, that's about 84 seconds per person that we are talking to. So that's really not a lot of time when you're thinking about, getting the right person for a fit on a jury trial. In Marion County, we also get the questionnaires from the juror the morning of trial. So we come in at about 9 a.m. We get the questionnaires and we go through them. The jury comes out. We start conducting voir dire. And then usually we have a jury selected by about lunchtime, and then after lunchtime, we begin presenting our evidence. So that's a really quick timeline to select these 12 or 6 people that are going to be deciding on the outcome of our case. I'm told that in other counties, the attorneys get to do voir dire, a week out or maybe a day before the trial, but we do it at a much quicker pace in Marion County because obviously we have so many cases. We're not able to necessarily set the jury selection process out that far. So that's just one thing, I wanted to make sure everyone was aware of. Based on the type of case we have, we have different approaches to each one. I'm going to walk through some of that with you. So in Indiana, jurors get an instruction during the trial that states that under the Constitution of Indiana, you will have the right to determine both the law and the facts, and that the court's instructions are your best source in determining the law. So this is a really huge responsibility that we are asking of jurors, to determine both the law and the facts of the case. The facts, are really determined by the evidence at trial. And I think that, is something that most people are usually prepared to do, making a judgment about whether they think something is true or not, whether they think a witness is credible. But I think that, determining the law can be a little bit trickier. And, it's not that the jury's coming in and making the law. They get instructions on what the law is, and then it's up to them to decide how they're going to apply it based on the court's instructions. Now, obviously, the attorneys have all gone to law school, and we've, thought about these things for a long time, but a lot of people are just waking up and rolling into court and, getting these complex set of instructions. So it's very important for us to talk to jurors about that during the selection process to see, are they going to be fair in the way that the court is asking them to apply the law in this case? For, one example I'll give you is that, the state has elements that we have to prove on a case, and the court will give instructions as to that. So say for a murder case, for example, the court would give the instruction that the state has to prove 4 things, and that's that the defendant knowingly or unintentionally killed another human being, just those 4 things. But from time to time, there's always someone during the voir dire process when we talk about those elements that might say that they believe that the state also has to prove a motive. That's not going to be in the court's instructions for a murder case, but sometimes just based on people's life experiences and what they see on TV, that might be a perception that they have, and they might feel that the state still has to prove motive. Even though that's not in the instruction, that's something, that we're going to be asking about and making sure that we don't have someone on the case that's not going to be able to apply the law in the way that the court is asking them to. But like I stated earlier, we are very limited during jury selection. So essentially, we can't try the case during jury selection. We cannot give all of the facts of the case. I have the case law here for you that proper examination of juries is designed to disclose the jurors' attitudes about the type of offense charge. The parties can attempt to uncover the jurors' preconceived ideas about a defense the defendant intends to use. And to make these determinations, the parties may pose hypothetical questions, provided that they do not suggest prejudicial evidence not adduced to at trial. So essentially, we can't share the exact facts of the case. It would be really nice if we could, but that is not something we can do during the voir dire process. One thing we can discuss is anticipated defenses. I would say one of the most common ones we have is probably self-defense. So if we anticipate that self-defense is going to be a factor in our case or something that the defense, is going to bring up, we'll talk to the jurors about that and kind of see what their attitudes are and their perceptions. Because the court, again, is going to give instructions on the law about self-defense, and it's going to say that the person could avail themselves of self-defense if the force was reasonable that they used. But that's another one of those questions that we want to know, what is reasonable to you? Because what may be reasonable to one person is not going to be reasonable to another. So that's another thing that we are discussing during the selection process. So another thing we're always planning for is how are jurors going to feel about the offense that we've charged? Because despite all the evidence on a case, a jury can ultimately decide that they refuse to convict just because they don't believe in the law. This is called the concept of juror nullification. Our Black's Law Dictionary tells us that juror nullification is a jury's knowing and deliberate rejection of the evidence or refusal to apply the law, either because the jury wants to send a message about some social issue that is larger than the case itself, or because the result dictated by law is contrary to the jury's sense of justice, morality, or fairness. So essentially, what that means is that the jury can, hear all of the evidence. They can, believe that maybe that this thing occurred, that the state is alleging occurred, and they can come back and say, even though we believed it, the person's not guilty. This actually happened to me on my very first jury trial. This was a level 6 felony resisting law enforcement case using a vehicle. In that case, the vehicle that was used was a 4-wheeler or an ATV, whatever you want to call it. And this person was just fleeing around through a neighborhood on a 4-wheeler, going through yards, knocked over a fence, did all of these things that were destructive to the neighborhood, running from the police on this 4-wheeler. And we had a lot of good evidence during that case. We had the 911 call, we had witnesses that saw it, we had multiple police officers come in, and we presented all of that to the jury. And then at the end of the trial, they came back in under an hour with a not guilty. So I talked to the jury after that case, and one of the jurors came up to me and said, we didn't convict because I just didn't think that this should have been a felony. And so that is, what I would, describe for you as juror nullification is it's just this idea that even though the state met its burden of proof and, the jurors believed it, sometimes they're going to just not convict because they don't necessarily care. They don't believe, in the charged offense, or don't believe that it should be a felony. I think that this is very common with a lot of our misdemeanor cases and some of our resist cases, because, resisting using a vehicle is a level 6 felony. And sometimes it's hard for people to get on board with that. So one thing we do during voir dire to try to see, who is going to be on board with that and who's not, is use hypotheticals and use questions, to determine what their perceptions are going to be. So, I might ask, why do we have laws that criminalize resisting law enforcement? Or what are some things that can happen if people run from the police in a vehicle? I can't get up there in closing and say, well, he could have killed somebody and say things that didn't happen in the case. But during voir dire, I can ask those questions, why is this important and why do we criminalize that? And usually, jurors will get on the same page with the point we're trying to make, but, sometimes they don't. And sometimes they may not find that they think that this is a particularly important thing for us to be enforcing. And we see that a lot with resist cases, especially. But because I just talked about a resist case, I do want to talk about a resist case where a person actually did die. And how there was a different kind of issue in that case. And I tried this case in 2016 with prosecutor Mears, actually, and the lead count on this case was resisting law enforcement causing death, which is a level 3 felony. And in that case, the defendant was charged with 12 counts. They were all stemming from a high-speed chase in a vehicle following a theft from Walmart. One person was killed during this high-speed chase. A young boy was severely injured, and another woman was seriously injured. At the time of the chase, or at the time that the defendant had hit the other vehicle, police had actually terminated their pursuit. They decided that the high-speed chase that they were going on was too dangerous to continue, so they stopped. But the defendant made eye contact with a police officer in a police car just seconds before he ran through a red light and smashed into the vehicle. So obviously there wasn't a nullification issue there when we were discussing, resisting law enforcement causing death, the jury, but there was a legal question for us, and that was Matthew Edmonds resisting at the time he crashed into the vehicle? So, we had to get creative to kind of see, how are jurors gonna deal with that issue? Because it's obviously very serious, and we believe he was resisting at the time, and that was why we filed it that way, and that was why we were going to trial on that matter. But it's hard to know whether jurors are going to also agree that the defendant was resisting at the time he crashed into the vehicle. So this kind of it is a good example of when we use hypotheticals because we can't talk about the facts of the case. So obviously during voir dire, we couldn't get up there and say, hey, this is what's going to happen during this case. And this is how the defendant was running from the police and how they ended their pursuit. We couldn't say that. So I came up with this hypothetical about kids playing hide and seek. And the hypothetical was that the kids were playing hide and seek and one of them broke their mother's vase. And we wanted to determine the possible perceptions from our jurors about, resisting causing death based on that. We'd ask questions like, was Jane still playing hide and seek if she was hiding under the bed, but Jack had stopped looking for her? What if Jane saw Jack sitting down during the game and still ran to go hide upon seeing him? I am sure that some of the jurors were a little annoyed that we spent, 20, 30 minutes talking to them about hide and seek. They probably came in and they're like, why are these attorneys just constantly asking us about this game? But, at the end of the day, after the trial, they convicted on all 12 counts. So I'm sure that they probably understood the importance of it after the trial was over. But it's one of those things that if you're ever, on a jury, or if you're in the jury selection process, if attorneys are using a lot of hypos, there's usually a good reason behind it. That may not be apparent to you at the time, but it is an important thing that we do. So another thing that we are always planning for is jurors' expectations in terms of the evidence at trial. We ask during the jury selection process, what type of evidence do jurors expect to see in the case, depending on the types of charges that we have. And this question, I would say, almost always leads to a strike because there's at least always one person that says, well, I wouldn't convict if I didn't see it on video. Or there's, someone that says, well, you should have gunshot residue, or I need to see a gun. In a lot of cases, we're not going to have evidence like that. So we spend a lot of time talking about the types of evidence that we do have and why that is, and walking jurors through situations that they may have had in their life. And we talk to them about, what kind of evidence would they have in that situation. Shows like CSI and fictional crime shows have really made it tough for us because they have a lot of what I would call junk science and science that we don't actually use, or our crime lab does not use. Things like gunshot residue. People expect to see that a lot on our cases, but our crime lab has said that gun testing for gunshot residue actually leads to so many false positives. It's not a science that we typically use. But, we want to know what jurors' perceptions are on that issue and make sure that they understand that maybe what they see on TV is not necessarily something that they're going to see at trial. And whether, that they're still going to be able to be fair in that situation based on a lifetime of seeing these things on TV, or maybe having an expectation that everything is caught on video when we are prosecuting a case. So at the beginning of a jury trial, or at the beginning of jury service, when jurors come in, they are provided with a juror questionnaire. They fill that out, and that goes to the court and to the attorneys on both sides. That questionnaire includes a significant amount of information, including, occupations, ages, arrest history. All the information that is in the questionnaire is not necessarily brought up in court. And I think it's important, for you all to know if you are ever serving on a jury and there might be some facts that you may think are really personal or could be embarrassing. The attorneys are going to do, we're going to do the best we can to be sensitive with that information. For example, if you have a family member that's been arrested a lot, or you or yourself has been arrested, or you have a particular medical issue that you are putting down in your juror questionnaire. We're going to ask questions in a way that we're not bringing out unnecessary facts in front of other people just to embarrass you. So if there were a lot of arrests in your family, we might say, you and your family have experienced some contact with the criminal justice system. Is that going to impact your ability to be impartial? But I think it's important that people know that because, people can be a little hesitant to share personal information for good reason. But I assure you that the attorneys and the judge is we're all going to go out of our way to make sure that you're comfortable and that we're not putting you in a position to have to overshare in front of other people or it'd be embarrassed in any way. So now I want to talk about some of the reasons that we can strike jurors. A prosecutor can strike a juror for virtually any reason related to their view concerning the outcome of the case. But as Judge Borges also talked about previously, the Equal Protection Clause forbids a prosecutor to challenge a potential juror solely based on the account of their race or the assumption that a certain race of jurors as a group will be unable to impartially consider the state's case against the defendant of the same race. So essentially we can make a strike, for any other reason, but it cannot be for race. We can strike someone based on the answers they give. We don't like them and we think that they're not going to be fair in determining the evidence. We can make a strike because we don't like their perception on the evidence. We can make a strike based on their attitudes toward, attorneys when they're answering questions and talking to us. If I'm trying to make a lot of jokes and someone is not laughing at my jokes and everybody else is, I might be wary of that person and I might strike that person for that reason. So there are a lot of reasons we might do that, but obviously our Batson challenge is something that, is very important. And, that a defense attorney, if they believe a prosecutor has improperly struck a juror based on race, they'll make a Batson challenge and the prosecutor will have to state the reasons for the strike to the judge. And I added in our jury rules on peremptory challenges. So just so you know, there are two different ways we can strike jurors, and we can strike jurors with a peremptory challenge or for cause under our jury rule 18, and I've included the link for you there. 20 strikes we're allowed 20 strikes and a death penalty and life without parole case, 10 strikes for murder and major felonies, and 5 strikes for all other cases. We can use these strikes or we don't have to use any, but those are the limits on how many we get. We can also challenge a juror for cause, and with those challenges, we have an unlimited number. The main reasons that we would challenge people is usually because they seem to have expressed an opinion about the outcome of the case, and they've said something that makes it seem that they are unable to be fair no matter what the evidence is. Someone might say something like, my cousin was killed by a police officer and I will never trust a police officer no matter what they say. That might be something that we would challenge for cause, just basically stating that this person has made it clear that no matter what the evidence is, they're not going to believe it and they're not going to be able to be fair. So there are unlimited amount of strikes for cause. And I would just also note that we can strike someone for cause if they are a defendant in a pending criminal case, because for obvious reasons, that would not be someone that should be properly serving on a jury in this jurisdiction. But ultimately, it is very important who stays on a jury. We can only exclude people. We can't pick them. So that can be kind of frustrating at times. There might be someone that's giving really great answers and we really like them, but we can't write their name down and say, I would like this person to remain on the jury. So calling it selection, is not technically I think the proper way of putting it, because it's really excluding the people that we don't think will work for us. And then, we're left with whoever is left there on the panel after we've used all the strikes. I always think it's interesting to talk to a jury after a trial and just kind of see what their thoughts are from the beginning to the end, whether they convict or whether they don't. We always, talk to them and try to get their feedback on a case. That can be frustrating because sometimes, they do things that they said that they weren't going to do during the voir dire process. But, we always learn from it nonetheless. So I have been talking for a while, so I will end with that. So I'll try to stop sharing my screen.
Well, thank you once again, Lindsay. I appreciate your very thoughtful presentation, kind of giving us the attorney perspective as we walk through voir dire. I'd encourage everybody in the chat to continue to ask us questions. I've received a number of questions from folks that we are going to get to. And so I'm also going to bring in Dan Cicchini, who, as I mentioned, had experience both as a defense attorney and a prosecutor, tried both major felony cases on both sides of the aisle. And so my first question, I'm going to turn over to Dan, but Judge Borges, you have question number 2, and it's actually about your experience as a sex crimes prosecutor. Dan, we've heard a lot about the state. Why don't you share with us your thoughts when you were a defense attorney? What were some of the things that you were looking for as a defense attorney going through the jury selection process?
I was a defense attorney for several years, and like Ryan said, I did do some major felony work, including homicide cases. In many of those cases, I wanted folks with an open mind, because there were a lot of cases where the state was holding a pretty good deck of cards against my client, and I needed to get creative with some of my arguments and get creative with some interpretations of the evidence. So in terms of folks who I would want on my jury if I were a defense attorney, or again, just folks who are ready to listen, folks who want to hear the evidence, and I would really try and get an understanding about what beyond a reasonable doubt meant to those individual people. It is defined, as Judge Borges could tell us, there's a definition under the law that she would read to the jurors, but it's not a percentage game. It's not a numbers thing. We can't say that beyond a reasonable doubt is 90% or 95%. It's not reduced to a statistic like that. So I would want folks who are really going to hold the state to their burden, that beyond a reasonable doubt means beyond a reasonable doubt, and that they would really carefully consider all the evidence, because it is such a serious subject matter.
And I think that's the important thing that I hope everybody takes away from this conversation is there's no good or bad juror. It's whether or not you fit for a particular case. And this is kind of a nice segue into our question for Judge Borges. Judge, you've been the judge on many sex crimes cases, and you were also had experience as a sex crimes prosecutor. And unfortunately, we have to talk about some things that most people would rather not know occur in our community, and some pretty serious and graphic allegations sometimes involving kids, and some really difficult things that people have had to go through. From your perspective as both a sex crimes prosecutor and a judge, how do you try to prepare jurors for some of that sensitive information and materials that they are going to hear should they serve on a jury?
Okay. Well, I'll tell you, it's not always easy, because sometimes what jurors are going to hear is going to be something that's really disturbing. And they're going to know some about it, and they may or may not have testimony from the child themselves, especially I'm going to talk first about child molest cases, because I've had jurors tell me, I just could never sit on a case where this is alleged. And it always makes me sad when I hear that, because those are some of the cases where it's so critically important. And what I normally ask in voir dire is I'll say and I have it written down that I use it every time, just because I want to be real careful in how I say it. In this case, a child may be required to testify. The law says a child has the same right to come to court and be heard as an adult. Can you be an adult who will carefully listen? So that's sort of the most difficult kind of case. Rape cases are difficult as well for a lot of different reasons. As people, we all have such a wide, varied background of things that have happened to us. When I was a prosecutor early on doing sex crimes cases, one of the questions I would ask, I would pick one of the jurors that I thought looked sturdy. It looked like the way they were talking to me, I thought they could take it. And I would ask them to tell me the details of their last sexual experience. And usually there would be this big gasp, and I would say, stop, I really don't need to do that. But the reason I asked it was because I wanted them to think for a moment about how difficult it is to actually talk about intimate matters. It is difficult. Sometimes it's hard for children to get out the words. It's hard for some victims. One rape case I had was a woman who was horribly raped and bound, but she would not talk about the intercourse. because she had the belief that it made her look like a bad woman somehow. And literally I had to take a break in presenting her evidence because I got emotional because I couldn't get her to say it. But it's hard for jurors to think about, I'm going to have to listen to things I don't want to hear. But it's part of the process. And I'm going to be as gentle as I can in getting that evidence in. And the prosecutors and defense attorneys that have been in front of me have been so gentle and careful with those witnesses, that it really isn't as bad as it sounds. I always hate it when somebody says, I just can't listen to a child, because they've had to tell. And so it needs to be evaluated. It needs to see if it really rises to the level of an offense. I had a victim one time that I was interviewing, and this was prior to trial, and I'm asking her, can you tell me, was there a time when some part of his body touched some part of your body? And she's very tearful and says, yes, there was. And I said, well, can you tell me, can you just point to where on your body you were touched? And she pointed to her neck. And I said, well, could there have been any other part of your body where any part of his body touched? And she said, no, right here is the only place he touched me. I said, well, did he say anything to you? Trying to develop this. And basically I looked at the prosecutor, and I was a defense attorney at that time. And the prosecutor looked at me and she said, well, I was going to dismiss that count. I thought, oh my God, that's just so scary, because now I've got a little girl who thinks she's a molest victim, right? So, I mean, and it is really important that the evidence be tested. And I think the lawyers are just excellent in how they present these things. I'm sure Lindsay and Dan both have perspectives about that. I don't know if I answered your question. I hope so.
Yeah, no, thank you very much, Judge. And Dan, when you represent someone who's accused of crimes involving, some difficult allegations, is there anything that you would try to say to the jury to prep them for what your defense might be, and also just your desire to have them keep an open mind, given that when we read count one, child molest, that people just have a natural visceral reaction to hearing those words?
Yeah, one of the things that we'd always talk about is, is by virtue of the fact that this person, man or woman, being charged with a crime, do you think that they're guilty? Is just the fact that they're sitting here in court, we're getting ready for a trial, just these allegations, does that alone make you think to yourself, you know what, that person wouldn't be here if they didn't do something wrong? And there's nothing wrong with that answer. A lot of individuals think that, hey, if somebody's been accused of a crime, it must mean they did something wrong. That's not the law, but it's important for us to know that. And it was especially important when I was a defense attorney to know that, because we just want jurors to be honest. And if somebody's thinking to him or herself as they're there, somebody wouldn't make that up. That's not a crime that somebody would allege without it being true. Children wouldn't lie about things like that. Those are all really difficult issues to get people to think about. And if just by virtue of the allegation or just by virtue of the charge itself that they're not going to be able to be objective about it, to listen to the evidence, that's something we would have to know right away.
Lindsay, going to the chat, one of the questions centers on this issue of diversity, and what role does diversity play in jury selection? I think it's important for everybody to note that there's no requirement that there be a particular gender breakdown or race breakdown on jurors. The only requirement is the process that brings people to the courthouse to serve as jurors was administered fairly. And sometimes that produces results where we have juries that very much reflect the community that we live in, but sometimes based on who shows up or who doesn't show up, it doesn't always look that way. So Lindsay, looking at the chat, there's this question about diversity and what role does diversity play in the jury pool and jury selection. Can you just talk a little bit about that topic and that issue? And Dan, we'll turn over to you after that.
Yeah, I mean, diversity, plays a huge role, not just diversity in race, but diversity in thought, diversity in opinion, diversity in experiences. If we have a case that's, involving a certain type of people or religion, that those things are all going to come into play when we're looking at which jurors are going to be fair and which jurors are going to, really understand this evidence, in the way we present it. When we talked about, the issue of Batson challenges, defense attorneys, stating that, maybe if a prosecutor, in most commonly, in my experience, it's when if I strike a Black juror in a case where we have a Black defendant, I have gotten Batson challenges before. As a Black woman, that has occurred to a defense attorney has made a Batson challenge. And I think a lot of times that comes from the frustration that obviously, an individual wants a jury of their peers. And, the defendant in that case, if they happen to be a Black individual, they're going to want the jurors to be Black, if at all possible. So, that is a reason that I think some of those challenges come up, even when, maybe the prosecutor may not be making it for that reason. It's the frustration of maybe not, feeling like that they are adequately represented by the jury. And, certainly we wish we could bring in more jurors sometimes than we have, but, we have what we get and we have who shows up.
Dan, from your perspective as both a defense attorney and prosecutor, talk to me about this issue of diversity in the jury pool.
It's hugely important, and it's important for both sides. And the reason for that is we refer to a jury of one's peers, and our community doesn't look like one single person. Our community looks like a lot of different people, and to have that represented in our jury box it just makes it a more fair system. It makes it a more representative system. And I think it helps people trust in the system more if they look across, if they are charged with a crime or if they're a witness in the case, if they look in that jury box and they see a makeup of people that is more reflective of the community. Judge Borges touched on it a little bit, but one of the things that is really challenging in Marion County is our response rate to jury summonses is incredibly low. As Judge Borges mentioned, she would send out 300 summonses or 300 orders for people to come downtown for jury duty, and maybe 50 people show up. Those 50 people are self-selecting at that point, and we have lost control to an extent of how diverse our jury panels could be. So if somebody gets a jury summons, if a friend or family member does, the best thing you can do is say, don't get out of it. Go to the courthouse, participate in the process, be a part of it, because I don't think there's any better way to get ownership, have a stake in your community than by participating and holding accountable or acquitting individuals who've been accused of a crime.
Absolutely. And Judge, you talked about that issue and that challenge of getting people to come downtown and serve as jurors. You, from your perspective as serving as a judge, number one, if you know, how do we figure out who is going to be in our jury pool? What types of information do we look to? Is it voter registration? Is it BMV records? What do we consider in trying to develop that jury pool? But then, a lot of times we have that challenge of who actually shows up and who comes downtown. So if you can just talk about what that process looks like in terms of how someone could find themselves receiving a summons, and then what remedies does a judge have if we don't have as many people show up as we would like?
I usually say that that you've been called to serve as a juror because your name is on a list that was certified to the court by the Supreme Court. And your name gets on that list if you are registered to vote in Marion County, if you have an Indiana identification card or Indiana driver's license, if you are paying taxes in Marion County. All of those things are things that can get your name on that list of folks. So we've really tried to broaden the scope to get as many people as we could possibly get in our jury pool. And so what happens then is that list is accessed randomly through an algorithm. Another one similar to the one they used to take the list of people who do show up and then put them in random order for me. And so, we've done a couple things to try to get people in. I know that Judge Stoner has previously, and I too have had an occasion to see people who didn't show for jury duty, send them a summons to appear to explain why they didn't show up. A show cause hearing to show, basically under the law, it would be called to show cause why they should not be held in contempt of court for failing to obey the court's order. That has limited value, because it's scary to people. For one thing, we're not in the business of trying to scare people. We just want as many people to come as we can. So we do have that wide variety of folks who are qualified to serve. One of the other things that's worked is that has helped, I think, is we have had some public service announcements. We've had people help us with that. I think that also has had some limited effect, because people really don't want to interrupt their lives and come spend the day with me, even though it's so much fun. I always tell them, listen, if we have you during a mealtime, we're going to get pizza for you. It's going to be great. So, so I don't know. I wish there was a way to reach out more. And I think doing this is one way that we can get people educated as to what's going to happen. I've had a lot of people say, oh, well, I can't serve because I have a test. And I'm like, let me reach out to your professor. I know, and your job, whatever, you can't be punished for serving on a jury. So we've tried all sorts of things. I try to be really helpful to jurors who are trying to come up with reasons not to be with me. I don't know if that answered your question.
No, that's great, Judge. And I think it's important for everybody to know that it's when you receive that summons, it's not an invitation, it's an obligation. You are being summoned to appear, and in layman's term, you're being ordered to show up to the court because it is such a vital and important role in our process. And someone asked, can you volunteer to be a juror? And unfortunately, no, we do want it to be random in terms of who shows up. So it's not something that you can volunteer for, but if you do receive a summons, we'd obviously encourage you to show up. And it's not something your employer can ever hold against you. If you are asked to be on jury duty, we're not asking, we're telling. And because of that, no one has the right or the ability to turn down that invitation if they are legally qualified to serve as a juror. Dan, talking about legally qualified jurors, I noticed that we saw that you have to be at least 18 years of age. Is there an age limit? What's the statute say about age requirements?
Excellent question. The only age limit is the minimum, as you said, 18 years of age. There is no maximum age for which you are automatically disqualified from jury service. However, if you are 75 or older and you let either the jury pool know, so the folks who call you to let you know whether your number has been called to serve, or you let the judge know when you get to court, if you wish to be exempted from jury service, you may do so, but it is not a requirement. So just because you're 75 or older does not mean that you are disqualified from jury service. You'll be an excellent and capable juror.
And when we have this conversation about juries, I mean, it is just a foundational part of our system. And, I know judges have gone to other parts of the world to see how they determine whether or not someone's innocent or not. Judge, I know just being in your courtroom, we've actually had people from around the world come in and observe jury trials and observe how we conduct business, because it is a little bit different than other countries. Just in your experience as a judge and your conversations with people not only around the country, but around the world, can you just talk a little bit about the uniqueness of this system and how we select people and the whole jury process? We actually have someone who's working for us right now, who is an attorney, licensed attorney in Africa, and they don't have jury trials. And she was really interested in this topic of, wow, you guys have jury trials. What does that look like? How does that take place? And so if you can just talk about the uniqueness of the American system, the American criminal justice system on this point.
We are extremely lucky in our country. And one of the things the United States citizens value our freedom. And one of the blessings of being a citizen of the United States is that you have the right to serve on a jury. You have the right to vote, which means you can participate in your government in selecting the folks that are going to serve. And then that right to serve on a jury as a part of the government, with that concomitant law that says our jurors have the right to determine the law and the facts that Lindsay talked about earlier. It's a wide range of responsibility for our citizens. I usually say, we're one of the few, there are more countries that are moving to jury trials. But I'm going to point right now to Afghanistan and what's happening there. The rights of the citizens of Afghanistan are extremely different than what we have here in some other countries. Very, very different. 3-judge panels, and they're the ones who make the decision. So there's a tiebreaker judge, that would make those decisions because they're supposed to be versed in the law, right? Well, sure, I do know the law. I've spent the better part of my adult life studying law and practicing law and presiding over jury trials. But that does not mean that I should substitute my judgment for the community's judgment. So here we value the community. We value our citizens and what they think, and they have that right to help fashion what is justice. And I think that's critically important. I may not always agree with what the jurors have decided. That doesn't mean that they weren't right. It's always difficult, especially if I was a prosecutor. I didn't want to lose ever, right? Because I believed in what I was doing. But you know what? I don't get to make that call. I only get to do what's appropriate, right? So I just think it is pretty rare in the countries of the world. So there are citizens and peoples all over the world that don't have the same rights and responsibilities that go with those rights that we have here. I'm so grateful to the jurors that have served in my courts. They're brave people that have done a very important job.
No question, Judge. And Lindsay, I'm going to turn this over to you, and then Dan. Judge Borders made a great point there about the uniqueness of our system, but also that in a lot of other places, it's judges who ultimately determine outcomes. Being both the legal practitioners here in the great state of Indiana, here in Marion County, we have juries decide a lot of the outcomes of our cases, which is 12 random people. It could be any 12 random people from anywhere in Marion County, which is both a great thing and a terrifying thing as an attorney. Lindsay, talk to me a little bit about that process. How do you feel about the process? The jurors often, there's a lot of questions about jurors being professional individuals. Jurors can be anybody. They can be doctors, lawyers, engineers, basically anybody but a police officer is able to serve on a criminal case. And they can come from anywhere in our community. Talk to me about the idea of, let's just take these 12 random people who could have very different levels of education, very different life experiences from any part of the city, as opposed to having a judge who has spent their entire career learning and studying the law. Is it better to have random people from the community make these decisions, or should we just have judges decide those things? So a very philosophical question. Lindsay, what do you think? Dan, going to you.
I thought about this a little bit in preparing for this, which do I prefer? And I think, what it really boils down to is I really do, believe in the fact that defendants do have a right to a jury trial, and that they do have a right to be judged by their peers. Obviously, a judge, has been to law school and, is qualified to make a decision and to give a verdict or on an outcome of the case. But, jurors have a lot of experiences, and, just the fact that, they're going to be the ones to decide, whether we have met our case, beyond reasonable doubt, is scary to me, obviously, sometimes as a prosecutor, because I have no idea what they're going to do. I don't know these people. I can't prep them. The judge, sometimes we have some expectation as to what they might do based on what we know about the judge. But that's why, you know, the selection process is so important. And I'm glad that we're able to, you know, have the opportunity to do that. But I can't really say whether I have a preference one way or another. I think it just depends on the type of case, the court you're in, especially, and just maybe even the climate of what's going on socially and in the world. You know, I can tell you that, you know, if there's, you know, something really bad going on in terms of the police at that given time that we're trying the case, we might have jurors coming in with a bad attitude about our case if there are a lot of police involved in it. So really, I mean, it's having a jury is just, it's reflective of, you know, just the attitude of the community at that time. And we never really know what we're going to get. So it's definitely not a sure thing. But I can't really say one way or another, which I would prefer. Sorry if that's not a good answer to your question.
Dan, same question to you, judges versus jurors.
It's when you take a minute to really think about the jury system, it is profound and incredible that we entrust at the end of the day somebody's liberty, potentially the rest of their life, just profoundly important decisions to ordinary members of the community. And that is a really powerful check on prosecutors, on the community, on the law. And, you know, folks, I guess I say that because I'm still pitching everybody to answer their jury summonses. But I really like jury trials. There are a lot of unknowns in terms of who's going to walk in the door, what are their backgrounds, what are their experiences. But I think that getting those 12 folks together and entrusting the decision to them is the right thing to do. 12 different opinions, 12 different backgrounds, 12 unique individuals who are all evaluating the case and deciding whether we, the prosecutor's office, have met our burden. I mean, that is a great system. It's time consuming. It's a lot of work. It's a lot of stress, but it is a really excellent way to resolve that, and it is an important check on the power of government.
I think it's also a great reminder that we serve the community doesn't serve us. And it's just so critically important that we're responsive to the needs of everything that's going on in our community. And, you know, just because we think this meets the law school definition of something doesn't necessarily mean that the just result is a guilty verdict or not guilty verdict. And I think it's really valuable to get that community input. And all of us who have tried cases have probably disagreed with the jury decision at one point or another. But that in no way undermines the process or the value of the process. You know, as prosecutors, we shouldn't win every time because that means we're not taking difficult cases to trial. We also shouldn't lose every time because, you know, that probably sends the message that we're not taking the right cases to a jury trial. And so I think it's a really important point in discussion. But it's part of what makes our criminal justice system great. And I think it's a strength of our criminal justice system, not a weakness, is that we get that public participation. I will get everybody out here on this. And it's always, you know, they always talk about primacy bias versus recency bias. The last thing you're going to hear is from the smartest person on the panel, Judge Borges. I will get you out of here on this. Judge, any final thoughts on the jury selection process or anything you'd like the 98 people who are on this call to take away from the voir dire or jury selection process?
I guess the only thing I would say is it's not something to be afraid of at all. You're not going to be asked to do anything that you are not capable of. We make decisions every day, what way to go to work, whether to have coffee or tea, what to have for dinner, which I can never figure out. But, you know, we do make all these decisions all the time. You're given the tools to make the decision. And it's something you'll remember forever. I think we're put in situations where we're needed. And maybe that means that the universe has put us in a position to make a decision because we have certain qualifications that maybe don't even show. So don't be afraid to come to court. It's really, you know, I'm not scared there. I lived there for so long, but a lot of people find it a difficult place to come to and a little scary. We want it to be dignified and we want it to be important. But just know that everybody in the courtroom wants you to be there. wants you to be comfortable, and wants you to do this job. So I really appreciate getting to be here. Thank you so much for inviting me.
Judge Borges, thank you. We certainly appreciate you appearing on this panel with us. Thank you very much for sharing your wisdom and expertise. Lindsay and Dan, always great to see you. Thank you for participating. We're going to be right back at it next Wednesday, October 13th. We're going to actually walk you through a case analysis. It's going to be a case that I personally prosecuted. It was a triple murder case that took place a couple of years ago. And I'm going to team up with my co-counsel, Selita Scott, who's our chief legal counsel, as well as retired homicide detective Harry Dunn, who was the homicide detective at the time of this case. And it's called Dialed In. And we're going to talk to you about how we really relied on cell phone evidence to help secure a conviction. And it's also a great reminder that when you post things online, it's there forever. So please don't think that just because you delete something, we, the prosecutor's office, can't have access to it, because we can't. And so we're going to tell you a little bit more about that process next week. Thank you, everybody, for joining with us here today. Great panel here today, and we hope to continue the very thoughtful and lively discussion next week, October 13th, same time, same channel, and we look forward to it. Judge Borges, thank you, and thank you to everyone who joined us. And you are 1/4 of the way to a t-shirt, so we're getting close. Thank you.